Hello, and thank you for joining us for this narrated PowerPoint presentation on the General Data Protection Regulation, GDPR, for clubs and class associations. I am conscious that GDPR compliance feels like a ginormous topic, and the fact that there is so much information out there available from different sources, it is often at times confusing. With that in mind, this presentation aims to provide you a working platform from which to understand the regulation and what you need to do in order to ensure that you are compliant with it. The presentation will therefore give you an overview of the regulation. We will look at how it applies to your organisation. We will consider what actions your organisation needs to take in order to ensure that it is compliant. And we will look at the resources available to help you on your road to compliance. The GDPR comes into force on the 25th of May 2018. It's the first EU-wide piece of data protection legislation for some 20 years. It aims to modernise data protection, giving citizens, that's you and I, more rights over our data while allowing businesses to use modern data management techniques. It seeks to offer greater transparency and accountability, thus giving you and I more reassurance on how our personal data is used by businesses and organisations. Notwithstanding Brexit, the regulation is coming into effect in the UK. Indeed, it is seen as important to ensure continuing e-commerce relations with Europe. It will apply to sailing clubs, class associations and training centres insofar as they are acting as data controller or data processors, and we'll talk more about the definitions of those in a later slide. The aim of this presentation is to set out what the new responsibility looks like, and it's worth bearing in mind that the law sets the bar to perfection, but it is hoped that the Information Commissioner's Office, the ICO, will provide guidance that will help to clarify these responsibilities. I think one of the reasons the GDPR has received so much media coverage is as a result of the fines that the ICO may impose. Under the GDPR, there is a two-tiered sanctions regime where breaches of some of the provisions of the regulation by businesses could result in fines of up to 20 million euros or 4% of annual global turnover for the preceding final year, whichever is the greater. Other breaches of the regulation may result in fines of up to 10 million euros or 2% of annual turnover, whichever is the greater. So we're not over-exaggerating when we say that the fines for a breach of the regulation could potentially be huge. It is worth noting that the ICO will have significant discretion as to whether and the extent to which fines will be imposed on an organisation in the event of a breach. If found to be in breach, clubs and class associations are highly unlikely to attract fines of 10 or 20 million euros. However, the ICO is likely to impose a fine that will reflect a club or class association's annual turnover and is thus going to be damaging for a club. So when we talk about data, what do we actually mean by that? Well, the GDPR refers to personally identifiable information, more commonly referred to as personal data. Now this means any information relating to an identifiable living person who can be directly or indirectly identified, in particular by reference to an identifier. Now identifiers include someone's name, someone's address, their date of birth, telephone numbers, their email and their birthplace. This list is not exhaustive, and more information on this can be obtained from the regulation itself. The GDPR refers to sensitive data, a term you may be familiar with under the Data Protection Act 1998 as special categories of personal data, special category data. These categories, which are listed on this slide, are broadly similar to those under the Data Protection Act, with the addition of genetic data and biometric data, where they are used to uniquely identify a person. I suspect that the types of special category data you are likely to be processing are medical records, data for minors, health data, and financial information. This data is more sensitive as it could create risks to a person's fundamental rights and freedoms, and because of that there are additional safeguards involved in the collection and the storage of special category data. In order to process special category data, you will need both a lawful basis for doing so and you will need to comply with a separate condition. We talk more about lawful basis later on in the presentation, but for the time being, the separate condition that you are likely to have to rely on, in addition to your lawful basis, is that of explicit consent. This means that if you need to collect health data, for example, you should do so on a separate form. This will enable you to detach it from other personal data and store it securely. The form must include affirmative, explicit consent for the holding of such data. The Data Protection Bill, which is currently making its way through Parliament, will contain more detailed guidance on the special category conditions, so watch out for that. So having considered what data actually is, i.e. personal and special category sensitive data, we now need to consider what the regulation means by processing of data. The processing of personal data refers to an operation or operations performed on personal data or on sets of personal data, whether by automated means or not, such as collection, recording and structuring, the full definition of which is set out on this slide. Essentially, if you are capturing information, for example, members' details on a form, a membership application or renewal form, perhaps an open event form, and you input that data onto a computer system, or perhaps you keep it in a paper format which is filed, you are processing personal data. The GDPR applies to both data controllers and data processors. Both controllers and processors are persons recognised in law. That is, they can be individuals, organisations, or incorporated or unincorporated bodies of persons. The majority of clubs and class associations are either unincorporated or incorporated bodies of persons, and they are therefore classed as data controllers. Data controllers determine the purpose and means of controlling data, and data processors are responsible for processing data on behalf of data controllers. Data processors are therefore under the direct control of the data controller as to what they do with the data. Data controllers are therefore obliged to ensure there is a contractual arrangement dealing with the processing of data between itself and the data processor that is GDPR compliant. Data controllers will often use data processors for the processing of the data of individuals. For example, a club may use a management system such as duty man. In this scenario, the club would be the data controller and duty man would be the data processor. However, just because a data controller uses a data processor, this does not relieve it of the responsibility to ensure compliance with the GDPR, as a data controller is obliged to ensure that its data processors are also GDPR compliant. Data controllers have more responsibilities and obligations under the GDPR than those of data processors. Data controllers must take appropriate technical and organisational measures for the protection of data subjects and their rights, and importantly, they must be able to demonstrate this. Under the regulation, data processors must ensure that they process data according to the principles and that they protect the rights and freedoms of data subjects, and they, like data controllers, must be able to demonstrate compliance with this requirement. By looking at the definition of both data controllers and data processors, I hope to have demonstrated that in the vast majority of its dealings, a club or class association is likely to be a data controller for the purposes of processing their members' data. So, having looked at the various parties and definitions surrounding them under the regulation, I hope that it is apparent to you that probably the majority of the information you request on your various forms, obtaining information from visitors, suppliers, members, staff, volunteers, etc., will all be classed as personal data. This includes names, addresses, dates of birth, telephone numbers, email addresses and emergency contact details. And as we've discussed already, information regarding health and disabilities is special category data to which additional safeguards apply. There are 6 core data protection principles which form the basis for the processing of personal data, and they are crucially important. They are very similar to the principles under the Data Protection Act 1998. The first of these concerns the lawful, fair and transparent processing of data. Personal data must be processed in a lawful, fair and transparent manner in relation to the data subject. Transparency implies that information and communication concerning the process of data must be easily accessible and easy to understand. Also, clear and plain language needs to be used. More specifically, this principle ensures that data subjects receive information on the identity of controllers and the purposes of the processing. The second principle concerns purpose limitation. It means that personal data is only to be collected for specified, explicit and legitimate purposes and is not allowed to be processed further in a way that is not compatible with those purposes. The third principle is data minimisation. According to this principle, personal data must be adequate, relevant and limited to what is necessary in relation to the purposes for which they are processed. Essentially, it means that data cannot be processed unless it is needed to process them in order to achieve the above-mentioned purpose. The fourth principle is accuracy, and this means that it is necessary to ensure that personal data is accurate and up to date. The fifth principle is storage limitation. This means that personal data must be kept in a form that makes it possible to identify data subjects for no longer than is necessary for the purposes of the processing. Storing data for longer periods is allowed when the processing of the data is aimed at achieving purposes in the public interest. The sixth data principle is integrity and confidentiality. This requires that the processing of personal data is conducted with appropriate security in mind. This should include protection against unauthorised or unlawful processing, destruction and damage. Appropriate technical or organisational measures are to be taken in order to comply with this principle. Such data security measures can include the use of encryption and authentication and authorisation mechanisms. In addition to the 6 data protection principles, the GDPR introduces the principle of accountability. In accordance with this principle, a data controller is responsible for compliance with the 6 data protection principles and must be able to demonstrate its compliance with them. It must implement appropriate technical and organisational measures and show how it has done so, for example, by means of training of staff or volunteers, data audits and document processing actions, such as producing a privacy policy and policies around data retention, data destruction, data minimisation, etc. A data controller may only process a data subject's personal information if it has a lawful basis for doing so. This requirement is not new. It replaces and mirrors the requirement under the Data Protection Act 1998. However, because there is more emphasis under the GDPR on accountability, it is necessary for data controllers to ensure they document their lawful basis for processing. The GDPR sets out 6 bases for processing. No single basis is more important than another. What basis you use will depend on your purpose and your relationship with the data subject. The first lawful basis for the processing of data, I think clubs and class associations should consider, is that the processing is required for the performance of a contract. I think that the majority of data that clubs and class associations capture is likely to fall under this heading. For example, the majority of the information on a membership application form is going to be necessary for you to perform the contract with the member, i.e. enabling the member to be a member. There may be instances when you can rely on the legitimate interests of the data controller as the lawful basis for processing data. In order to rely on this basis, you will have to carry out an assessment of the impact on the data subject. In certain circumstances, your lawful basis for processing may be to protect the interests of the data subject. This is about protecting an individual's vital interests, and this condition may apply in cases of life or death, and we think you can rely on this basis for capturing next of kin emergency contact details. The next lawful basis, being a legal obligation, is unlikely to be terribly relevant to the majority of clubs, although there may be circumstances when you may need to rely on this basis. Essentially, this occurs when the processing is necessary because of a legal obligation that applies to you. For example, VAT records. Under the Data Protection Act, clubs and class associations used consent as the lawful basis for processing personal data fairly extensively. However, the GDPR makes some changes to consent which make the use of it as a lawful basis for processing a less viable option. Under GDPR, consent must be unambiguous and involve clear affirmative action, informed, specific and given freely for each processing purpose. Silence or inactivity are not sufficient. Moreover, consent may be withdrawn at any time. Because of this, we recommend that you do not use consent as the basis for collecting membership data, or indeed any data that is necessary for the performance of your contract with that individual, as if consent is withdrawn, how can you deal with that person as a member? The lawful basis for processing is an important element of the GDPR, but it is too big a topic for us to go into full details here. We therefore recommend you use the IC website as a resource for further information on this. Let's take a moment to consider the key changes under the GDPR. Firstly, the definition of personal data has been expanded and now includes genetic and biometric data. There are new rules around when and how you are permitted to process data. That is the legal basis for processing. We've just looked at that on the previous slide. At the same time, we considered the issue of consent and the fact that it is no longer the recommended basis for processing due to the ability for a data subject to withdraw their consent. Individuals have always had rights under the existing data protection legislation. However, the GDPR enhances those rights and introduces a new right to be forgotten, and we'll look at that a bit later on in the presentation. Data subjects are entitled to much more information under the regulation, and accountability principle is new and requires more documentation to evidence compliance. Under the Data Protection Act 1998, it was a requirement to register with the ICO and pay a fee unless you were exempt from this requirement. The GDPR does away with registration. However, there is still likely to be a fee to pay. More information is awaited from the ICO on this. And as we've already looked at, the fines under the GDPR are greater than under the current legislation. And the GDPR extends the territorial scope to the processing of personal data of data subjects in the EU by a controller processor who is not established or located in the EU if they offer goods or services to data subjects in the EU, or if they monitor the behaviour of data subjects where that behaviour takes place in the EU. So, how do you get ready for the GDPR? Well, first of all, we need to say that the GDPR is more extensive than the existing Data Protection Act. However, if you are already complying with the existing Data Protection Act, you are likely to be well on the way to compliance with the GDPR. In order to get ready for the GDPR, you will need to establish whether your current policies and procedures are suitable and comply. If not, you will need to alter them. So ask yourself, do you know what information you have relating to your members, coaches, instructors, volunteers, employees, business contacts, visitors, etc.? And do you know why you are keeping it? Here are some steps to compliance to get you underway. Firstly, preparation. You need to know about the GDPR, so you might want to think about getting yourself booked on some training courses, and then you might be able to deliver some of that knowledge to your volunteers, staff, etc. Whilst you're not obliged to appoint a data protection officer, I think it would be sensible for you to appoint someone at the club or class association with responsibility for overseeing data protection on behalf of your organisation. Perhaps you'll want to create a working subgroup with responsibility for data protection. Next, we recommend that you carry out a data audit to look at what information you have already, what systems you're using, and whether you've got any policies. There's more information on this on the next slide. Next, carry out an analysis of whether or not there needs to be some policy updates, system changes within the organisation. To help you deliver on your GDPR obligations, you might want to produce an action plan for the whole organisation and think about extensive training, or rather ongoing training, for key members of the organisation. Finally, you need to think about how you're going to manage your ongoing compliance obligations. GDPR is not a one-time tick box exercise. Your compliance with the regulation must be reviewed on a regular basis. The first step on the road to compliance with GDPR is to carry out a data audit. This is a review that assesses what personal data you are currently holding and whether you need it, where it came from and the legal basis on which it was collected, what you do with it and what you are planning to do with it, where and how you store it, when and how you destroy it. This is an opportunity for you to have a sort out of your data, to really think about what you are collecting and whether you do in fact need it. Importantly, you'll keep a written record of your data audit. Having carried out your audit, you hopefully now know what data you are currently holding in relation to your members, volunteers, etc. It's time now to ask yourself, do we actually need all of this data? Can we get rid of some of it? Can we depersonalise some of it? And should we have consent for some of the data we hold? If you haven't already got one, you will need to adopt a privacy policy that's available to all your stakeholders. You may need to review your governing documents. Quite often they will have a statement in them about deemed consents, and this will need to be removed. If you are using consent as your lawful basis for processing, for example, on the use of imagery, you will need to ensure that your consent form complies with the GDPR, and importantly, that data subjects are advised of their right to withdraw their consent. If you are using a data processor for the processing of any of your information, you will need to ensure that you have adequate written agreements in place with them. In line with the accountability principle, you need to document everything you do. Having carried out your data audit, this is your opportunity to make sure that you get everything in time for the deadline on the 25th of May. The rights of individuals exist under the Data Protection Act 1998, however the GDPR enhances them, so we will take a brief look at them now. The right to be informed relates to information that you should provide to data subjects. The information should be clear, transparent and easily accessible. This right takes the form of a privacy notice or data protection policy. Such policy will set out the legal basis upon which the data is processed, how long it's going to be retained, and it will set out more data subjects' rights, including how to make a data subject access request, and how to request the deletion or rectification of data. And it will also set out the extent to which it may be transferred overseas outside of the EU and the appropriate safeguards that are put in place to protect such a transfer. The right to be forgotten is a new right under the regulation, and it's actually formally known as the right of erasure. This involves the deletion or removal of personal data where there is no compelling reason for its continued processing. So a data subject can make this application when the data is no longer necessary, or the data subject withdraws consent and there is no other legal basis for processing, where the data is unlawfully processed, or to comply with other legal obligations. The erasure of personal data must be carried out without undue delay, and a data controller must take reasonable steps to notify third parties who hold data on the individual that the information must be deleted. The right of access relates to an individual's right to be aware of and verify the lawfulness of the processing of their personal data. Such a request takes the form of a subject access request, and we have provided some detailed guidance on this for your information, which can be accessed by the hyperlink on this slide, or alternatively from the Club Zone area of our website. The right to rectification enables a data subject to ask a data controller processor to rectify personal data that is inaccurate or incomplete. Data subjects in certain circumstances have the right to block or suppress the processing of their personal data. The GDPR introduces a new right for individuals, that of data portability, and this right exists where the lawful basis for processing is consent and the processing is carried out by automated means. A data subject may be able to obtain and use personal data for its own purposes across different services. Data controllers are obliged to provide data relating to the data subject in a structured and commonly used and machine-readable format in order to transmit to other data controllers. Individuals have the right to object to the processing of their personal data in certain circumstances. A data controller must stop processing unless it can demonstrate compelling and legitimate grounds for processing which overrides the rights and freedoms of the individual. And finally, individuals have rights in relation to automated decision making, including profiling. The rights of individuals is too extensive a topic for us to go into very much more detail in this presentation. However, the ICO website is a useful resource for further detailed information on the subject. It is possible to obtain insurance cover for your data protection obligations. Cyber insurance is currently available on the market, which covers data protection breaches and resultant fines. Cover is not currently incorporated as part of the RYA club policy with Arthur J. Gallagher. However, this will be added to the policy as an optional extension in the very near future. In the meantime, it can be arranged through Arthur J. Gallagher separately. I suggest clubs and class associations contact Ben Bennett at Arthur J. Gallagher to explore the options. The ICO is responsible for the enforcement of the GDPR, and the ICO's website contains lots of useful information on enforcement. We've mentioned it earlier, but it's worth reminding you that there may be substantial fines involved for a breach of the regulation. I think it's worthwhile pointing out the risk to clubs as we see it. The ICO is likely to be concerned with enforcing against larger organisations initially. It will get far more media coverage that way. However, smaller organisations still need to comply with the regulation. The ICO doesn't have the resources to go out and to directly police the regulation. However, the risk to clubs is likely to come from disgruntled members reporting the club to the ICO for a potential breach. At the beginning of this presentation, I mentioned the fact that there is a lot of information that is available on the GDPR, and sometimes that in itself is confusing and a little bit overwhelming. So where should you go to get more information on the regulation? What resources can you trust? Well, we suggest a good starting point is the information that we have produced on your behalf, all of which is listed on this slide with hyperlinks. This information sits in the club zone area of our website, and we are updating it all the time, so it's a really useful web page to bookmark and keep referring to. The Information Commissioner's website also contains lots of information, which again is constantly being updated. The ICO have a helpline, the number's on this slide, so you can contact it direct to discuss any issues you may have. Finally, we'd say come and talk to us, pick up the phone, send us an email, and we'll see how we can help you. Thank you for joining us for this presentation. I know that the GDPR can seem daunting at times, but I do firmly believe that if you approach it in bite-sized chunks, it is manageable. I hope that we've been able to help you get started on the road to compliance, and perhaps more importantly, advised you of where you can go to get further information.